Everything okay?
Yes, sir.
You heard anything about our friend?
No, I have not.
No.
All right, good morning, everyone. Again, time now is 9:04 a.m., October 16, 2019, calling this meeting of the Wayne County Ethics Board into session. We're going to move into our order of business, starting with A on our item on our agenda, which is the roll call. At this point, we'll take roll call.
Mr. Young is requesting an excuse. Mr. Hendricks?
Here.
Ms. Hamoud?
Here, good morning.
Yep. Dr. Carnell requested an excuse. Ms. Bucero, not here yet. Judge Thomas?
Here.
And Mr. Pinkins?
Here.
Mr. Chair, you have a quorum present.
Great, thank you.
Yeah.
Moving on to our next order of business, item B on our agenda is the approval of the minutes of the September 18, 2019 meeting. I just want to ask to make sure every member has received a copy of the minutes from the September 18, 2019 meeting.
I did.
And has everyone had an opportunity to review those meeting minutes?
Yes.
Yes.
Is there any objections to any of the minutes
Move
as they are
approval,
written?
Mr. Chairman.
Second.
All in favor?
Aye.
Aye.
All opposed? The ayes have it. So moved. Moving on to the next order of business on our agenda, which is item C, which is unfinished business. Under item subsection 1, communication from Keisha Lynham regarding the Treasurer's Office employee. Good morning, Mr. Williams. Have you had the opportunity to discuss any further matters with Ms. Lynham, and do you understand that she's going to be here today?
Good morning. I have not had a discussion with Ms. Lynham. I do understand that she is here. I have seen everything that has been exchanged with both Mr. Parker, the Treasurer's Office, emails that have gone back and forth. All I agreed to do was put my recommendation in writing. Nothing I've seen has changed my recommendation. In fact, it has only confirmed what I still recommend, that this is not an ethics board issue. I mean, having read it all, there's a lot of back and forth on issues that are way beyond the ethics ordinance, including personal residence exemptions, calculations, meetings, agreements. I'm just not seeing any violation of the ethics ordinance that's related to some contractor or employee.
And so at this point, your recommendation would be?
It's still the same. Dismissal without prejudice. I know Ms. Lynham is here, so.
Okay, so is there any motions before us at this time? And I know Ms. Lynham is here. I'll call her forward to if she wants to come and participate. Ms. Lynham, good morning. Good morning, Ms. Lynham.
She's hard of hearing.
Yeah.
Yes.
She reads
She'll
lips.
have her hearing aids here.
No, fine.
Ms. Lynham, good morning. Can you understand? Can you understand me? You can hear me?
Yes.
Okay. Good morning. Thank you for being here.
Right, your microphone's.
Okay, thank you.
So you have a device here that's going to help you to proceed to. Does this help you to? Because I understand you can read lips, right? Is that correct?
Yes.
Okay. So with the device that you're wearing, does that help you further?
Yes. I can hear you.
Okay. Oh, so you can hear me through that.
Yeah, that's why I was standing over
Wait,
back
let me
there.
Oh, okay.
I didn't need to sit at the table today. But thank you for inviting me.
No, thank you for being here. So obviously you heard just what the attorney for the board has recommended. Do you have anything you would like to add on your behalf?
Yes. On my behalf, I'm not really sure, like, the ordinance and different things like that, and the procedures that the employees must follow. But however, they had disregarded every procedure that has been set in place, I guess, by your organization. I gave Mr. Joe a few of the items that I have to show that the PRE, I'm not really even sure. That's another issue that I have to deal with the city. I've been the sole owner of my house since 1998. I'm not really sure what happened of why my PRE was even removed, because it's,
Okay.
for the most part, has always been my principal residence. So I took the necessary steps to have it put back in. And I spoke with Cheryl at the assessor's office maybe about one day last week, and they granted it to me for 2014, 15, and 16. However, the county has not adhered to that as far as putting the PRE in order to reduce the base taxes. And then on top of that, the interest is being calculated on the amount without the PRE. And that's why I had refused to make the payment arrangements. But however, I went on ahead and I went in, made the payment arrangements. Unfortunately, I did it only because I have to have a place to live, and they kept threatening the fact to foreclose on my home. So I went on ahead and made the payment arrangements, but at the same time, I expect you guys to do, or the county to do, what they were supposed to do as far as following the procedures and putting the PRE in to reduce the base taxes, which will reduce the interest.
Okay. Let me just stop you for one quick minute. Let the record reflect that we've just been joined by Ms. Buciero. Good morning, Ms. Buciero.
Good morning.
And just getting back to Ms. Lynham, do you understand what this board's jurisdiction is? Have you had a chance to look at a copy of the ethics ordinance? Because and the chair's understanding is there's recommendation out there by the attorney for the board, and that recommendation is basically we don't have this board does not have jurisdiction to hear your complaint because you don't really allege an ethics ordinance violation. It seems like what you're alluding to is more of an administrative issue with the treasurer's office and yourself. That's generally not within this board's purview to delve into matters like that. Now, again, we'll hear from other board members to allow their input, but that's the recommendation. Do you understand the recommendation that's before this board right now is to basically dismiss your complaint because you don't allege any violations that fall under the ethics ordinance?
How so?
You haven't named a violation under an ethical ordinance violation. You know, what you're basically stating, and correct me if I'm wrong.
Looking at the ordinance, I'm not really sure what the section codes or anything like that, but not following work ethic and procedures is a violation of that code. I spoke with, I guess, the attorney or something. They said that they were going to recommend for a dismissal, but I don't think that it should be dismissed because it is a problem. It's an issue that has been ongoing for 3 or 4 years. So, I mean, give you a car and tell you to pay $10,000 for that car, knowing that that car is only worth $5,000. Would you be okay with that? No. So somebody just throw you in a mountain and say, here, pay it. I'm not okay with that. Because this is where I reside. This is where me and my children is living. And being forced to be put out and things like that because I don't choose to pay the amount that you set forth. No, follow the procedures and then set the amount and then I will maybe pay it. But I'm not going to pay for anything that somebody just threw a number in there. The procedures as far as the computer-wise are not in place.
Okay. Have you spoken to anyone in the treasurer's office to resolve this matter?
I've spoken to everybody that I possibly can speak to before I came here. Nobody would resolve this issue, and so this was my last resort, is to come here. I spoke with Mr. Cavelli. I spoke with the manager that was in room 520. I've spoken with the clerks at the window. I don't know what else to do anymore.
Okay. Does any board members have any questions?
Just a quick
for Ms.
question,
Lynham?
Mr. Chairman.
Mr. Hendricks.
So is the issue the value of that's been placed on the property, which resulted in the taxes being too much?
Correct.
Sounds like that's what the issue is. And, you know, the mechanism for addressing that would be the Detroit Assessor's Office, right? Where you go every February, you file an appeal, you say this property value is out of sync with its market value, and they have a mechanism for you to appeal that value to reduce it, which would ultimately reduce the taxes on it And they also have, the interest issue is a treasurer's issue, city treasurer and I guess the county treasurer. But they also have a hardship mechanism in the assessor's review and board of review timeframe, all in February, where, you know, you can get some consideration. So, you know, that to me sounds like is at the heart of what's going on with the value or the taxes on your property, that it's been overassessed maybe for way too many years, and the city of Detroit, again, has a mechanism, especially if no one has been out, an appraiser has been out to see the property in years, to say, hey, you guys need to come out and look at this property. It's not worth this. And they would do that. And so, and as far as past years are concerned, there may be some mechanism for that too. I'm not sure. I've been away for a long time.
Well, in calculation, it would reduce the interest if my PRE is at 100%. My PRE, they're charging it at 0 as if I don't live there. Okay? Putting the PRE in at 100% will reduce the base tax, which definitely would reduce the interest.
Okay. Yeah, that does.
You understand what I'm saying?
I do.
It's not about the property value or
Okay.
anything of that nature. It's about the 100% primary residence exemption that you receive from the city by living in your home. So if, say, like the taxes is $700 without the PRE, with the PRE, it may reduce it to like $400 and some dollars, which then will be calculated on at the interest, as opposed to being calculated on the $700 by it not being your primary residence. So that's making it a lot higher. So that's what I'm saying. Somebody just throw you an amount out there or whatever and say, here, pay it. And I'm saying, no, I'm not paying it because that's not what it should be.
Right.
So the thing is, in the database for the county, they don't have the PRE in there. So they just sitting there with like $1,500 up there to pay for this particular month or whatever, for this particular year, when it actually should only be maybe $900. And then you calculate the interest off the base, which is $900 at 6%.
Yeah.
And my thing is also, I filed bankruptcy also in 2016. And under the bankruptcy laws, it says that you can discharge any old delinquent taxes prior to the years that I actually filed bankruptcy. So actually, my 2014 should be dismissed, and I should only be responsible for 15 and 16. So the amounts that I have already paid, which is maybe like $1,500, should all be going towards 2015 taxes, which actually 2015 should be reduced from 14 because my PRE is not in. They showed me, I can show you the paperwork that I just received from the county a couple weeks ago when I went on ahead and paid the $300 to make the payment arrangements. I can show you that versus what the actual tax statement says. They haven't changed it. They haven't fixed it.
Even when you mentioned the bankruptcy, those tax years taken off, the years that you did, you stayed, because I did see some of the information that you sent over. The chair did see that, and you do show that those years were allowed to be taken off with the bankruptcy. Now, did you bring that all up with the county? And how did you file bankruptcy? Did you have an attorney file this for you?
Yes.
Okay. Thank you. Since we have some people here from the treasurer's office, and I think they've been here long enough, I think they've heard some of your testimony here. I'm going to call them to come because I do want to, just while you're here and while they're here, see if we can get some answers to some of your questions here. I think Mr. Cavalli is here. Good morning, Mr. Cavalli, or either Mr. Fridge. If you can come forward, either one of you, if you could take a seat at the table, please.
Hi.
Good morning, gentlemen. Good morning.
Good morning.
Can you just introduce your names for the record, please?
My name is Roy Freight. I'm Deputy Treasurer of Forfeitures and Foreclosures.
I'm Tony Cavalli, Department Administrator over Taxpayer Services.
Okay, good morning, sirs. Now, gentlemen, I think you've been here, and have you had the opportunity to hear some of Ms. Lynham's testimony today? And I think what she stated, that she's been in contact with the Treasurer's office to resolve this matter. Is there anything you can add as to what is taking place here? She says that her PRE has been removed and hasn't been placed back. She said it's her primary residence. Do you have anything to add here?
Well, if I may, so I'll just speak about big picture here, and then Mr. Cavalli has worked on a lot of the details, so he can address them. But I just want to say that we are very sensitive to Ms. Lynam's questions, concerns. We have spent quite a few hours, many different people in our department looking at all the documents, replying with explanations, detailed explanations. We have everything documented. And every time we think everything is okay, including email responses that seem to indicate so, it seems there's additional requests. So we've been dealing with that as best as possible, replying. We have everything again documented, the answers to all of the questions and concerns, and we really thought this was resolved a while ago. And I think there's currently a ERSPA in place. There's a payment plan, but I'll let Mr. Cavalli respond to some of the other concerns.
Yeah, as far as the PRE, we did get notification from the city that had been reinstated, and we have made those changes in our system. We have copies here of the adjustments that were done a couple years ago. So those were done. You do have the PRE, which is why I asked our staff to make sure you were allowed to get into the ERSPA plan, because you could not get into that plan if your PRE was 0%. So I showed them where we had already adjusted it per the city to make it 100%, and that's why you were allowed to get into the reduced interest payment plan. Now, our system, when you come into our office to get a tax statement, it will show you the taxes and interest with the statutory interest and fees. We can't change that to what it will be if you get into the payment plan until you get into that payment plan. Once you get into that plan, then we can print you a new statement. Once the program is done running, print you a new statement showing how much it has been reduced. So if she has, I'm not sure if Ms. Lynam has a statement prior to her getting into the PRE and one after that, but the first one she got did have the PRE already, that school tax already deducted from her total amount. Now, if you look at it, it's going to be a lot less because the interest is 6% per month instead of 18%.
For what years?
For all years. The PRE can be for all years that are delinquent as long as you're the owner occupant. And that was the issue, is because she didn't have the PRE, we weren't sure.
But once it was corrected, it was retroactively adjusted for all years.
For the years that the city told us to, yes, because we can only adjust taxes per a court order or a court order from the Board of Review from the city. And that's where the bankruptcy comes in also. When people file bankruptcy, all of that does in our offices, it puts a stay on us foreclosing. Unless we get a court order saying the taxes must be removed, all the bankruptcy does, we get notification, we stop sending notices to people because otherwise it's harassment, and then it stops the foreclosure process. We can't foreclose on properties in bankruptcy, but it doesn't forgive the taxes unless there's a court order, and we haven't received an order stating that those taxes should be wiped out.
Yes, Ms. Buciero.
Yeah. So, excuse me, I'm sorry. How far back have you gone to adjust the PRE?
Roy's got the documents here. Whatever the city told us to do on the Board of Review, they can do the current year and 3 years back. So if they did it in 2018, they would have adjusted the 18 and asked us to do the 17, 16, and 15. But per the law, they can only do the current year and 3 years back.
So not all the way back to 2009?
No.
Okay, that was my question. Thank you very much.
No problem.
I have a question.
We did 14, 15, and 16. So they must have requested it in 2017, the city did.
I have a question.
Yes, Ms.
First payment agreement or payment arrangement that I had with you guys, it had not been adjusted. And I don't care what you saying at this particular time. I have proof right here stating that when I entered into the first payment arrangement, he said it takes time to adjust. That's not true, because I had been paying on that for over a year, and there still had not been an adjustment made. And I have statements from them and things of that nature that were sent through the mail that's stating the taxes are even higher from when I actually entered into the payment arrangement. So that's not true at all.
Do you have those with you here today?
Huh?
Do you have those with you here today?
Yeah.
Can you show those to
Give me 1
Mr.
second,
Cavalli? or Mr. Free?
What year was that, Ms. Lynham, that you entered into the first payment agreement?
This is one from September the 9th. September the 1st, 2019.
Okay, and so what am I looking at here? Is it just showing that, per the record, the chair has a copy that you've given?
This is the actual statement from the city. And that's without the PRE.
Okay. I'm going to ask you to let Mr. Cavalli take a look at this, and so we can get an
I showed
explanation.
it to him.
Okay, but while we're here today, and the chair, generally, like I said before, I think we mentioned this before, generally we're doing this because you are here today, and Mr. Cavalli and Mr. Fridge is here today. So we are trying to extend a little bit of accommodation to try and see if we can bring some sort of resolution. We don't want to venture off too much beyond what this board's jurisdiction is, but again, we did want to hear from you. If you can present this to Mr. Cavalli so that, Mr. Fridge, so that we can see if we can see if your PRE has been applied, if it's retroactive or not, while you're here today. Are you in bankruptcy right now?
I'm sorry?
Are you still in bankruptcy right now, or have you left bankruptcy, or are you still in bankruptcy right now?
No, I mean, that was like in 2016. I have those papers too, or whatever, that was discharged.
Okay.
But this is the first payment arrangement that I made, and this was back in 2017. And as you saw, the statement from 2019 that the adjustments had not been made, and this was the first payment agreement that I was entered into.
Okay.
And I kept receiving statements with it higher and higher, so I stopped paying it because I was like, if you just keep adding on, I'll never know what what I've accomplished or what I've paid or what I haven't, what is the actual amount that I need to pay.
Are you in foreclosure
stop.
right now? Are you in foreclosure status right now? Or are you?
No, I just went last week or whatever, and I entered into a new
URSPA.
payment agreement, and on this, it's still not adjusted.
Can I take a look at that?
I should have brought today's statement.
So my question is, how many payment agreements do I need to enter into before they actually place the adjustment on there?
You want to take a look at this? Okay. Can you show that to Mr. Cavalli?
So I know where I stand and what I need to actually pay. Maybe I can get a loan and just pay it off and be done with it. Whatever the case scenario, may be or whatever. I mean, I need to know what is it that I actually owe, not this amount. I have like another statement here. It has another different amount than the first statement that you saw. Every statement has a different amount on it.
All right, well, let me have Mr. Cavalli and Mr. Fridge respond. Mr. Cavalli, Mr. Fridge, thank you again. You've looked at these documents that
Yes.
she just presented. Can you answer any questions for her as to whether or not the PRE has been placed on it, why the difference in the rates, and why has it been? It seems like it hasn't been retroactive, it hasn't been applied. Can you answer her questions as to why that hasn't happened, or has it happened, or?
Yes, the document here is correct. This is a 2015 city tax bill, which was only good for the time up through February of 2016. Our office has subsequently got order from the city and reduced the taxes by $317, which was the PRE, the city granting the PRE. So this document is correct. At that point, it was zero, but we subsequently got an order to give her the PRE back, which reduced the taxes, and here's a copy of the adjustment from our system.
I have for the city all the corrected adjustments on the PRE, which is 14, 15, and 16.
So has that PRE been applied to those years as well?
Yeah, those are the three letters that I have here also. Those are the adjustments that the city ordered us to give her PRE back, which reduced her tax amount.
They're saying that the adjustments is in there, but if you look at 15, I mean specifically 15, it's the same total amount that the actual city statement is. That's without the PRE.
Let me hear from Mrs. Hamid.
Yeah.
You put the PRE in
Sure,
with the
recognize.
adjustments that they gave, then it will reduce it.
So with the paperwork that you have, do you know right now if she wants to pay everything, what would be that amount?
If she were to pay the balance, I didn't bring an up-to-date statement with today's interest on it.
Okay,
So I should have printed that before we came, I'm sorry, but that statement that we would get today would be her balance of taxes due with the interest at 6% because she has entered into the reduced interest
So what
payment
is
plan.
the total balance?
On here, her total balance is $4,654.50.
That's incorrect, though.
So 4,000, can you?
$654.50.
Okay, and those are from what year to what year?
That's 2014 through 2017.
Okay. Okay, and this is the balance without any, like, penalty or interest?
No, that's with the 6% interest and the
6%
penalties, yes.
As of what date?
As of 10/4 on here, that's the day she got into the...
October 4?
Yes,
Okay.
Of 2019.
2019,
Thank
yes.
you.
Thank you.
2019, okay.
Yes,
Because
that
I'm-
makes a difference.
Yeah. So as of October 4, okay, 2019, so this was the balance, including the interest and the penalties. So if she's going to go and request something like today, as she mentioned, like to whether loan or money to pay it off today, that amount will be increased by some interest accrued from October 4 until today.
No,
Plus any
no.
penalty, or like, okay, so.
The interest gets added on at the beginning of each month. So
Okay.
my question was, is this balance here correct? Is that showing at the 6%? I can't calculate it right away off the top of my head.
Okay.
Or is it still at the 18? So if it's at the 6%, then that's what her balance due is, and that's what it should be.
Okay.
But I don't want to give her that, and then it could be less. It's not going to be more. It could be less.
Thank you. So, may I continue, Mr. Chair?
Yes,
Okay,
Ms. Mahmood.
so, question, so when you say this is not the correct balance, because you're saying some of this is,
Should be reduced by the tax adjustments with the PRE.
okay.
And that's
So-
why I say that the amount that he's sitting there with, that's the incorrect amount. If he tell you he can't tell you off the top of his head, because that's there is just on paper, because that's the incorrect amounts. So he have to go and put it in the system and put the adjustments in, and then he will be able to calculate how much it is that I would actually owe at that particular time or whatever. My thing to you guys is that in going through this situation, as long as it has taken, it has cost me more money, more interest is what it has caused me. And I think that I should not be exactly responsible for everything up until the date that I started going there trying to get this resolved. Anything after then is on them. They have to, you guys maybe have to let them do something or whatever, because that's not my fault. I'm stressed out.
So may
You know,
I?
I can't do it anymore. I argued and pleaded with everybody.
Yeah, well, I understand where you're coming from. I just want you, like, to make sure that you're clear with the board's role. We have ordinance that we have to follow, and unless you tell us that somebody had whether conflict of interest or took let's say, gift and they benefit from not, doing what you're saying they did, situation like this, especially when it comes to assessment, it's their management responsibility. You can escalate it through that department. We're not gonna be here. Yeah, I mean, we're not gonna be here like the assessor's office or the city assessment, department. So I hope you understand when we're gonna defer this, because if I vote today, I want you to be aware, we're trying to do our job, but it's not our job to get involved. Now, we can have some directive and, to ask, from them, but we don't have any authority to be
I understand
able.
that.
So I just want to make sure that you understand. Thank you.
I think Mr. Hendricks has been waiting.
I just wanted to ask Mr. Cavelli and Roy, you understand what she's saying?
Correct.
And what is your response to her comment?
Well, the first
From a treasurer's perspective.
Right, the first one that the adjustment still hasn't been done, the amount that is showing on here, which is her tax due, is the amount of taxes due after we made the adjustment in our system, which I have here.
Right.
So we did the adjustment, and the amount that's due here on our statement that she has is the amount that's due after the adjustment. Now, as far as the interest, we are governed by state law. We can't reduce interest. We've done as far as we could by law.
Or penalty?
Right. We've done as much as we could by law by reducing it to the 6%, which is a new law that just got passed. Other than that, any other interest reduction or waiver has to go through the Michigan Tax Tribunal.
Okay, and that's what I wanted to try to get to, because the frustrating thing for a lot of taxpayers is that they get caught up in this cycle and circle, and they get, shoved around and pushed around. You guys have done, or believe that you've done, all that you are legally able to do.
Correct.
I'd like for Ms. Lynham to leave this table today with some direction to say, if you do this or if you go here, you can get some relief for what is the remaining outstanding issues that you have. And it sounds like you're saying the city of Detroit will do nothing else from your
Right, the
understanding.
city's out of it.
They can't go any further back than they did, the 1 year plus 3.
Correct.
So the Michigan Tax Tribunal is her next step
Yes.
to take all of the outstanding taxes, penalties, and the tax tribunal can they judge? They can waive taxes, they can waive penalty. I believe the tax tribunal has the jurisdiction to do all of that. For how many years, I'm not sure.
It would probably be two different
Cases.
appeals, one for the taxable value and then a separate one for the interest.
Now, and there is a tax tribunal court right here in Detroit, is there not?
That's on the boulevard,
Right, and you can go there anytime to file.
yes.
Where?
Where's that on the boulevard?
I'm not sure the exact address, but the state building where the old GM building used to be on the boulevard, that's
I know
the
what it
state building now.
Michigan Tax
I've
Tribunal.
actually had to go there once for a hearing, so.
The only thing I want to add to this or whatever, and I'm not trying to, be difficult or anything. I understand everybody has done everything that they can legally and things of that nature. All I'm saying is, when I first took this issue to the county or whatever in regards to the PRE, at that particular time, if the taxes, if they would have corrected it at that particular time, it would have been a lesser amount, and maybe I could have paid it off in full. That's all I'm saying. So now that it's been 3 years, it's so much interest more that's been calculated in regards to this matter. That's all that I'm saying, because if it was fixed 3 years ago, 3 years wouldn't be of interest when I first went to them. And all I'm saying is it could have been paid off at that particular time.
And just from the chair's perspective, just Mr. Cavalli, can you tell us whether or not, and this is just a general question, because the PRE was removed and had not been placed back then, I know it was placed back on before, is there any way your office can waive any further penalties because it was removed? And again, it seems like that was removed. Nothing with respect to Ms. Lynham, what she did. It seemed like it was removed, and that was possibly an error that was removed So is there any way, because of it was removed and it should not have been, what she's saying is all this interest was accruing that should not have been, that would not have been had she had the PRE in place at those times when what she's saying is they should have been in place. So is there any way, given that I know that they're back on now, but is there any way that your office, maybe not the taxes, maybe not the interest, but anything you guys can do with some of the penalties that's applied?
Nothing that I know of statutorily that we can do to reduce any interest or fees without a court order or an order from the Michigan Tax Tribunal.
Not the interest
Right.
again, not the taxes. You're saying that the penalties that's been applied.
Again, not that we're aware of that we can, we can't make those changes on our own without a court order. But I think Mr. Cavalli had some additional comments.
Yeah, and the city ordered this on the July border review in 2017. We processed the adjustment in August, and the only reason that it took us till August to process the adjustment is because the city, once they do their July border review towards the end of July, they have to balance it before they send it over to us to do the adjustment. So we did the adjustments on August 31st of 2017, which was probably the day after we get, because the city, when they do their border review, they send us an electronic file. It goes right to our programmer. He loads everything, the program runs, and everything is done electronically.
Okay.
So it was done in August of 2017.
Okay, I'm going to hear from Mr. Hendricks. We're going to have a few more comments on this matter, then we're going to have to move
So,
on.
I'm looking here at the Tax Tribunal's website, and a petition for appeal can be filed electronically. A docket number is assigned. This is small claims, by the way.
Yes.
Generally, if you go to the Tax Tribunal, there is someone on the other side of the table from Ms. Lynham defending whatever decisions have been made. Would that be you or the city of Detroit? I think it's the city of Detroit.
It would be the city of Detroit because she's defending them taking the PRE away.
Exactly.
Either the city of Detroit or the state of Michigan, because her PRE may have been denied by the state of Michigan. So I'm not sure who
And probably
took that
because
away.
they didn't have the information or didn't know. All I know, Ms. Lynham, is that at a small claims level with the Michigan Tax Tribunal, these judges and referees, they have tremendous latitude. They are not always on the side of the government or the city, and you've got a very strong and compelling case on so many different levels. You don't have to leave your house to file this appeal, to get a docket number, to get a notice of a hearing, and then instead of coming to a place like this, go to the tribunal with all of your papers. You may not even get anyone from the city to show up, or if they do show up, they may show up in a sympathetic position. You just don't know. But I'm looking here, and it sounds like the relief that you're looking for now, after all of this running around, unfortunately, because maybe somebody dropped the ball, the Michigan Tax Tribunal is the place of resort that you are right now to go in and say, here's what's happening, they dropped the ball, my PRE was incorrect, I continued to be assessed penalties and interest way beyond they should have been. Can you please give me an adjustment so that I don't lose my home? And it's all sitting right here, and I don't want you leaving here because we can't do anything.
Thank you.
You need some assistance, and there is a mechanism for you to get relief. And here is it. This is it right here, the Michigan Tax Tribunal, and you don't have to go to Lansing. It's right here in Detroit.
And on top of that, I think I would also add, you want also relief from the interest due to that issue by the city. Not just, I want the adjustment, but can I have some relief from some of the interest? Because if they order that to us, then it's just an order from the state, we have to do it.
So it's a dual appeal, as he said. It's the value, the assessment, and then it's the penalties and interest in addition to that that's been levied against you. That's really creating the problem for you, I think.
Okay.
Okay, now, so Ms. Lynham, did that answer your question? That what you need to do beyond this next step for you, that what you need to do?
I'll be on my way when I leave.
Okay, hopefully that assisted you in some manner. So with respect to and Mr. Cavalli is going to hand you back the paperwork that you've had. Again, I'm going to thank Mr. Cavalli, Mr. Fridge for being here. Oh, yeah, I think the chair has a document as well.
Well, I appreciate all you guys, huh?
If I may.
Thank you for being here as well, also, Mr. Fridge.
Just if I may say, I think Councilman Hendricks gave some very good advice even before we came up here. For future years, you may want to approach the city of Detroit, Ms. Lynham, to see if you qualify for the property tax exemption that they have. It's a great program, 50% off the taxes or 100% depending on your income if you qualify.
And it does have to be applied for annually. You can't just apply once and it carries on. You got to do that annually.
Okay, thank you for that.
Thank
So, at this point, Ms. Amuda, I know you have a quick,
I mean, I want to put a motion to dismiss then this complaint without prejudice.
Okay, so the motion is to dismiss the complaint without prejudice. It has been supported. Is all in favor at this point of the motion? Say, I assume, all opposed. The ayes have it. So moved. Again, thank you for being here, Ms. Lynham. Thank you all for being here.
Thank you.
Thank you.
Moving on to our next order of business. Item 2, under item C, subsection 2, is the communication from Denise Alexander et al. Regarding a circuit court employee. I believe everyone has that communication or has received a copy of her complaint. If any board member has not received a copy of Ms. Alexander's complaint, please bring it to our attention. At this time, I'm going to again ask to hear from Mr. Williams regarding any further communication with Ms. Alexander regarding her complaint. We'll extend them a little leeway. No, why don't we just have a brief recess if we can? A brief 10-minute recess, bathroom recess. Do we need a motion? Is there a motion for recess? No, I don't think you need a motion for a recess. Okay. We're off the record. We'll be back on the record in 10 minutes.
The medical bills. I get those all the time. Credit and stuff like that at the bank. It's like so complicated with penalty and interest and. I'm telling you, they can figure it out. The gold, it's not even the insurance. Breast cancer runs.
But yeah, she didn't call this past. She saw it.
Even if you call and they tell you, and sometimes like. Why would the hospital or your doctor didn't say?
And down the line, we keep those.
Two boys, and at one point
Is your progress a brick at a time?
They, every few years, they have to do bricks. They're like
put back, and they say they can't do it, because
they
they
have to
don't
do
know
scaffolding every now and then. It's,
I said,
yeah, that's.
have this day, I know how old TV.
Brick at a time,
What we have noticed over the years is that there is a lot of external
They
involvement.
turned off the water last night,
Oh, no.
so the water's gonna be off.
John's
Next few nights.
Noticed over the years that there are some external problems with things. Our building, this year.
We just bill at the highest
When the agendas go out, they go.
Yeah, Bill's a higher rate than I did.
Oh,
Bill for his rate.
Mr. Sabris. Yeah, it's because each of the electors, and I think maybe one person additional per.
Your nation, they love
I think, but you know, it's still the second
I'm
treasurer
telling
person,
you,
the only person.
it's like the stuff that they,
I have to get a new
really,
person, so.
if I knew, I wouldn't have. You would. Everybody got a laugh out of that one. Yeah, it's true. Okay, we're waiting for Mr. Hendricks.
Yeah, we actually put them in your packet, the photographs that she had sent me. Photocopy the originals, so they're in her packet. They're in Ms. Lynam's packet. So she took a bunch of photographs, they were with her cell phone, they were really bad. Yeah, they're in her packet.
Okay. All right, we're back on the record. Now I think we're back. We can move on to our next order of business. Moving on to our next order of business under item C, which is unfinished business. Item number 2, which is communication from Denise J. Alexander et al. Regarding a circuit court employee. And again, I think I'd mentioned, asked whether or not everyone had received a copy of the complaint. I believe at the last meeting we did discuss that complaint. Mr. Williams, have you had any further communication with Ms. Alexander or the respondent of the complaint?
Well, Mr. Chair, we did deliver a copy of the complaint to Ms. Gilbert, who is the respondent. We did go through some gyrations because we didn't want to just the only address we really had was a general address for at Frank Murphy Hall of Justice, so it took some work to actually get it into her hands personally, but we did do that. She now has it. Her response to the complaint is due on October 22nd, and then we have to give the response to the complainants, because I believe there are 4 of them, and they have 7 days to respond to her complaint with any additional information that they have, and then all of that information would be circulated to the board for its consideration, I assume at the next meeting.
So just in time frame, if the response is due on October 22nd, and from that point, then they will have 7 days to respond. Then that will put us where? Is that into early November?
Yes.
So is that saying technically we could put this matter on for a hearing at the next meeting of this board, or?
Through the chair, obviously the complaint due next week, Tuesday the 22nd. The 7-day window is the 29th, which is the following Tuesday. Then the following 7-day window is November 5th.
Well, I'm not sure that the hearing window is 7 days.
No, not the hearing window, the response window.
Yeah.
Was that 11 November was the second response back? It was November 5th. Now, all complaint. My understanding is this was a complaint filed, one complaint, but it's 4 people that are listed as complainants. So, would you need a response from each individual complainant, or just one response would?
There was only one complaint. I mean, about one issue brought by 4 separate deputy clerks. So my understanding is there's only one real issue that has been raised by them related to Ms. Gilbert, and I believe it's Ms. Gilbert and her husband, and that's the sole issue. They all have the same complaint about the one issue.
And if there is a response, and then we set this up for a hearing, the complainant, would that, because these are clerks, and I would take that, they day-to-day basis they need to be at work, running the courthouse. I would assume, or their individual courtrooms wherever they work in Wayne County or wherever they work there. For hearing purposes, would each one need to be here, or just would one suffice, or how would that work? This is just a question.
These miracle questions again. I guess it's a question of what their proofs are going to be and how they move forward with their complaint. Having not seen the response, it's hard for me to say how many of them are necessary to come forward with what they believe are the responses to the respondents' response to their complaint. I don't know that all of them have to be here, but it's hard to say because I don't know what Ms. Gilbert is going to say about her interface with her husband as a supervised employee by her. I mean, that appears to be the issue. I don't know if all of them have separate factual statements about that or not.
Okay. This time, is there any questions from any member of the board, from Mr. Williams, regarding this issue with Denise, the complainant from Denise Alexander et al. Regarding this circuit court employee?
Yeah, I think we just have to wait.
Thomas.
I think we just have to wait until we get the responses. And then we'll better know how to proceed and who the witnesses are going to be before us. And we also, because of the process we go through, it might allow the clerk an opportunity to resolve the whole issue without it having even to come here.
Ms. Hammoud.
Do we need a motion to table this to the next meeting? And should we define when the next meeting so at least the people who are involved, they can plan if they want to attend?
Motion we to pass for the day.
So, the chair understand that motion will be the motion to pass for today.
Okay, I can put that motion to pass for today.
Is there a second? All in favor?
Aye.
All opposed? The ayes have it. Motion approved. Moving on to our next order of business, new business, item D on our agenda, subsection 1, suggested changes to the ethics ordinance and road ordinance number 2014-734. I think we all have copies of those changes that we made back during the summer of early spring. Has everyone had opportunity to review some of those changes? Is there any objections, any additions anyone would, or any objections to the proposed changes at this time?
Mr. Chair,
Yes, Mr. Thomas.
am I correct that this is being submitted to us for our review to determine whether or not this is adequate in terms of the changes we recommended to be submitted to the commission?
That is.
Yes,
Chair.
that is correct.
Okay. So a cover letter would go with this to the commission with any other suggestions that we
Well,
made.
I assume the process, and perhaps Ms. Johnson, who is in the back of the room, can address it. I assume that the communication would come from me to Ms. Johnson with the board's recommendations in the form of this particular document, and that I don't know how it flows from there in terms of how it gets to the commission and what the appropriate process would be.
Okay. Thank you.
Well, since you raised that question, Mr. Thomas, and the chair would like to hear as well, since Mrs. Johnson is here, if she doesn't mind, if she can come forward and sort of answer a few of these questions. Good morning, Ms. Johnson.
Good morning, Alicia Johnson, counsel to the county commission. So the process would be that this body would submit it to the commission, address it to Chairwoman Bell, and then it would flow from that point.
And would the document would come to you, and you would then take it to Ms. Bell, or would it go directly to Mrs. Bell? Is that
The document would go directly to Chairwoman
Chairwoman?
Bell. So submitted officially to the commission, from the ethics board to the county commission, directed, addressed to the chairwoman. She will then distribute it to the appropriate staff for review.
Okay.
And it'll then flow from committee from that point.
Is there any further questions of Ms. Johnson? Hey, Ms. Johnson, thank you so much for that. Thank you. Okay. At this point, again, if there's, if all members have not had the opportunity to review the proposed changes, please state so. If not, then if there is any objections, please note them. And Mr. Williams, at this time, what is your recommendation with respect to the changes?
Well, I did give it to the board for review. Any additions, further corrections or recommendations they would like to make based upon the series of experiences we've had over the last couple of years in an operational context, I certainly believe the board should have an opportunity to weigh in on it, make sure they are comfortable with the document, and then I can transmit it to the chairperson of the commission after everyone has weighed in and made sure that all of the comments have been received and everybody's comfortable with what we send to her.
Ms. Johnson, just if I may, is there a time frame that we can, because once it's submitted to the chairperson, is there a time frame we can expect, or no, is this just all up to the commission? Does this have to actually go before the full commission, or are these adopted some sort of way? Is there a committee hearing on it, or how does this process work, from your understanding?
Through the chair, so the chairwoman has some discretion in how that process would flow. Generally, it would go to the chair's office. She would then submit it to staff for review. And then it's up to her to determine which committee it would go to, at what point it'll go to committee. That's all going to be determined based on the work we have and priorities that she sets. So at some point, it will likely make it to a committee. Let me say this. The last time we had suggestions from the ethics board, it eventually made it to a committee. The ethics board appeared. There was discussion. Some items were adopted, some items were not adopted, but any to be adopted or for any change to the ordinance to take place has to be voted on by the entire body.
So when you said the ethics board appeared, does that mean that the entire board appeared before the commission, or does that mean someone from the ethics board appeared?
Someone from, so at that point it was the former or then chair of the board actually appeared on the ethics board to have to discuss their revisions.
Okay. How long did that process take? Do you recall?
It all varies. It really does vary based on what we have happening at the time with contracts, scheduling. It depends.
So once it's submitted, Mr. Williams submits that directly to the chairwoman. Is it our understanding that he can follow up with her to possibly, I mean, if it's gone months and months, to possibly get some sort of feedback as to where we are in the process, or would that?
You can probably give a status from Joe or myself. I'm the chairwoman. I probably would say contact me or contact Joe. It'll likely come directly to me, and I'll probably lead my office since it is an ordinance. Usually, sometimes we have questions, so I may seek clarification and have questions before it gets to committee, just to make sure we're all on the same page and understanding why we're doing what we're doing and requesting. So there may be some opportunity for further discussion before it actually goes to the body.
Okay. Is there any further questions of Ms. Johnson? Okay. Thank you, Ms. Johnson. Okay, at this time, I'm going to give a little time for members to just review this before we take a vote on whether to adopt them and to formally send these over to the chairwoman for the county commission, or if there's any objections to or additions or any changes that need to be made beforehand.
Mr. Chair, I do have a question.
Yes, Mr. Thomas.
Dr. Carnell is not here today as a result of an injury that her husband suffered. And I would like to hear what she would have to say relative to the proposed changes, since she spearheaded the entire discussion that we had relative to changes that should be made to the ordinance, and to make sure that it's clear, because there were other things that we suggested should be made known to the commission that I don't think are necessarily in here. So I would really like to hear from Dr. Carnell in terms of all of those types of things, the other things that we discussed, as well as the changes formatted in the proposed ordinance that we have before us.
Point well taken, Mr. Thomas, and the chair has those same sort of reservations. I would also like to hear from Ms. Carnell. And I do think members may need some actual time to really take this and look over it. I'm not sure if all members did receive a copy of this or even had the opportunity to sit down and take a look at this and really go over it. Because we did spend some time going over this line by line, and I think we need to spend some time, not too much time, but time to make sure that the changes that we talked about are in here. And I do know other changes did come up in speaking in some of the meetings. So I believe there will be a motion to pass on this for today, possibly.
I would so move.
Is there a second? All in favor?
Aye.
All opposed? The motion is moved. All right, moving on to our next order of business. Under new business, under our item E of our agenda, such other matters as may properly be submitted before the board. Is there any other matters at this time before the board? I believe we do have to discuss our next meeting at this time, next meeting date. Mr. Slezak.
Through the chair, the third Wednesday in November, the 20th, is available. That actually is the 1 week before Thanksgiving.
Okay.
So that's not falling on Thanksgiving week. So the 20th is available. For November, the 6th and the 20th are the two available dates, the Wednesdays.
Is there any conflict in that date with the majority of the members?
The only issue I would have is that I have a 7:30 meeting, and I probably would be a little bit later.
20th. November.
On the 20th?
20th, yeah.
Okay.
I mean,
Okay.
do we want to push the time back possibly, or do we want to just keep it at 9? Or, I mean, it's up to the board.
Does anyone have any conflict with the meeting time of 9 o'clock? Any members at this time?
9 a.m.
9 a.m.?
on the 20th. Probably won't be able to make it. Just be a little bit late.
Okay, any other members have any conflicts with that time of 9 o'clock, or if you'd like to move it further?
I'm okay.
Okay. Any other members?
Good.
Okay, what we can do is, this time, Mr. Becerro, if you run a little late, I think that'll be appropriate, that we'll still start at 9 o'clock. Let's see if any other members have any time to that or any objections. If there's a motion for 9 o'clock, then we move for that. We'll keep it at 9 o'clock. If there's one to begin at 10, the chair will entertain it. Ms. Hammoud.
Go for 9 and
So move. So the second it or okay. All in favor?
Aye.
All opposed? So move. Meeting is at 9 o'clock, November 20th.
I have a comment.
Yes, Ms. Hammoud.
I know, if I remember correctly from last year when we started thinking about the annual report, did one of the elected officials had a comment to try to give them, if somebody submit a complaint, to give them that ahead of time? I'm trying to remember because now thinking of the changes to the rules or the procedures, when somebody, let's say, submit a complaint now, okay, we had a representation from the treasurer's office today, but let's suppose we did dismiss this or we make a decision. Are we giving them copy at least of that complaint? And should we think about that as a procedure or rules to give them a heads up? I'm just trying to avoid, because we're getting to the year end, I vaguely remember something about it, so I'm trying to be prepared.
I remember that as well.
I thought that issue turned on the criminal complaints more than the
We
general.
referred it to the Wayne County Prosecutor's
Yes,
Office.
and that they wanted, that we agreed to a process by which we were going to reference the statutory provision rather than the actual criminal referral in the report. That's what I recall was the concern by some of the elected officials.
Okay, and I know like from a knowledge standpoint, because like somebody, if I remember, I can't remember if the Register of Deeds, he said like to give them a, like, I do not know what the rule, if we can give them a summary of like the complaints related to that elected official. Like I know we had some now for the treasurer they should be aware of, but I don't know what other complaints that we process throughout the year, whether for the prosecutor's office or the Register of Deeds, if we have like those, maybe give them a copy ahead of time. I'm just speaking out loud just to not repeat, any miscommunication after we publish the report.
Mr. Williams, do you have any comment on that?
Well, the report itself normally goes to them. It is addressed to the elected officials.
Right, but I mean, did they ask like to review it before it's final and voted on, or?
No, that's not what
Okay.
No.
Okay.
I'm not sure there's much controversy this year.
Hope not. But
I mean, as I recall it, again, my recollection was the controversy was the criminal referrals that were in the report.
I don't know if the Register of Deeds had asked for, what you're referencing is a copy of the report before it is released to the public.
Yeah.
And,
That was kind of my recollection, and because like they feel like they are entitled to review it before it's official and voted and published.
Well-
But I mean, not that we may change anything, but if there's a wording or that we should be
I'm gonna
considering before the final vote and publishing it as a courtesy, I do not know, but I mean, I'm bringing it up from just last year's experience.
And the board does recognize that I think Mr. Hendricks has to leave early, and I think Mr. He has a flight he has to catch. Don't want to hold him up from that flight. So, Mr. Hendricks, when you need to, sir, you are excused. I think there's a question from Ms. Becerro.
More of a comment. I think that, even if we decided to allow all the elected officials to see it before it's released to the public, I don't think we should allow them to see it before we vote on it, because I don't think that they should have input on our vote.
Right.
Okay.
Yeah, that was going to be my comment.
And that is, through the chair, really sort of the difficulty of this process. Because this is a public body, in your hearings and consideration of what you are voting on goes into the public packet.
Mm-hmm.
It's kind of hard to address this sort of pre-review when it's coming to you as part of the agenda for consideration for a vote, even though it's a document that in the real world of attorneys it might go to the person for review beforehand. In the public body context, I'm not sure there's a way that we could necessarily do it prior to the vote being taken, because you have to comply with the Open Meetings Act. So there's just difficulties, and there's no pending litigation. You go into closed session, vote before.
I understand. I just wasn't sure if there is like a way to accommodate everyone and give them a chance, because we do public hearing to have let's say, okay, this is the draft, this is when we're gonna vote on it, even open it up to the public, and if one of them wanna come and discuss it or have a hearing about the final, we can allow them to do that. I'm just, again, thinking out loud here. So to make sure the process is fair to everybody before it's final and we have the stamp and this is for the rest of the year, you have to live with it.
Okay, so, I think that's been answered. Any other matters before this board? We're going to move on to item F on our agenda, which is any public comments. I'm not sure if there's any public comments at this time, so I believe we can move forward on to the next order of business, which is the adjournment, item G on our agenda. Is there a motion to adjourn?
So move.
Second?
Second.
All in favor?
Aye.
All opposed? Motion is moved. We adjourn. Thank you,
Mr.
everyone.
Chairman.
Thank you, sir. Thank you. Sure.
Yeah.
After you stop recording,